Edmond, Mack.
You were a protester.
I am a protester. That is true.
Are you familiar? Brief that was filed on behalf of the protester since more.
I am.
And when did you first become familiar with that brief?
When the drafting process began.
Did you draft the protest?
I helped with the drafting, I sure did.
Who else drafted it?
The attorneys in the firm that were involved,
Which year was that?
Plakas.
Is that the firm which you're employed under?
It is.
Did you draft the motion and the protest in connection with your employment at that firm?
My firm drafted the protest and researched the protest in conjunction with the attorneys in my firm and with the Ohio Democratic Party.
So let me ask, are you an associate or a partner of the firm?
I am an associate attorney.
And how long have you been an associate?
Been there for 10 years, thereabout.
You bill your time?
You,
Bill how many?
Howard,
You have previous hourly records of your time.
you
You bill the work for drafting the brief.
did.
And in respect to the ordinary course of business, your firm will be charging you.
I expect that there will be a bill that will be submitted if it hasn't been already.
When was the decision taken for you to participate in this matter as a protester?
That would have been when David Pepper came to Canton and talked to us about the protest.
When was that?
That would have been, I believe, the week after Mr. Bernabei filed his independent non-named petitions.
So the second week of May 2015.
I think that's about right. It could have been the same week, but I think that's about right.
Have you been assigned the drafting task at that time?
No.
So after you were assigned to become a protester, you were assigned the task of drafting on free.
I wouldn't say assigned. I was part of the team of attorneys at the firm that worked on the protest because I'm obviously intimately involved in Kansas City politics. A natural fit, and I would participate in the process.
So after you were elected to become a protester, you began the process of working on the brief as an attorney.
It's true.
Did it occur to you that as a protester, you were signing a declaration under the brief saying that you were advancing the protest based upon the allegations contained in the document itself?
Yeah.
All right. Did it occur to you that there's a disciplinary prohibition in Ohio between entering into a matter as counsel wherein one might be called as a witness?
That's not accurate.
Isn't? What part is inaccurate?
You would only be prohibited from testifying if the interests are adverse. My interests are clearly not adverse to the protesters.
You are a witness in this matter.
Sure am.
Did you willingly write the brief knowing that you might be called as a witness in the matter?
Yes.
So, as a protester or as an author, did you discuss your legal strategy with the other members of your firm?
Yes.
Which?
All of them.
Oh.
Wait, which attorneys in my firm? Well, there's 15 attorneys. We would have discussed it. Yes, it would have been discussed with the attorneys in the law firm.
Okay. In your capacity as a protester?
In my capacity as Edmond Mack.
How many hats does Edmond have to wear in this matter?
I am a protester. I am a Kansas City council person. I am an attorney. I am a firm that's prosecuting this suit.
What personal knowledge do you have that Mr. Bernabei did not subjectively in good faith attempt to disaffiliate himself from the Democratic Party?
I can't crawl on Mr. Bernabei's head, right? The only thing we can evaluate is what we have in the objective record. And if we're applying the standard in the advisory opinion, he's not disaffiliated from the Democratic Party. And there's certainly suggestion in the record and the evidence that the timing and the history of Mr. Bernabei's relationship with the mayor suggests that it was, no, that it suggests that his disaffiliation was not good. At least as that's defined by the Ohio Secretary of State. At least as that's how that's defined by the Ohio Secretary of State.
I'll circle back to that in a minute. Can you point to any post-disaffiliation action on behalf of Mr. Bernabei? that supports that conclusion?
Post-disaffiliate, so you're asking what he did to disaffiliate, or what he failed to do to disaffiliate? since he filed?
Post-petition.
Post-petition, what he failed to do?
Right.
He clearly failed to resign as a Democratic County Commissioner. If you look at your own board's records right now, it shows him as a Democrat County Commissioner, even though his address has since been updated to reflect the latest address.
Okay, let's run with that.
Sure.
Where in the law does it say that he is required to resign as a county commissioner in order to disaffiliate himself from the party?
Well, the advisory opinion says that that's something this board clearly will look at. And I think that the board's agenda that Mr. Plakas looked at, recognized that when you look at the factors that show an ongoing relationship, that's a big one. And then you look at the other factors, voting history, contributions, memberships in the Democratic clubs, showing up on campaign literature, reporting a commercial. Do you want to keep going?
No, I don't want you to. What I want you to do is answer my question.
I'm sorry.
Which was, where in the case law can we find any requirement that someone, in order to disaffiliate himself from a party, must resign in office that he was elected to during previous association with that party?
This is going to be that case. This has never happened before.
So the answer is there is no case law.
The
Is that the answer?
The advisory opinion says that's a factor you look at, but there is not a case where this is happening.
So rather than you telling the board what they're going to do, why don't you tell me that there is no case law? That's an accurate statement. of the
That is
law.
an accurate statement.
Okay. There's no statutory requirement either, is there?
To the extent you can't be affiliated, there would be. But if you're saying there's something beyond that, there's not.
General Assembly makes laws with respect to running for office, correct?
True.
General Assembly makes laws with respect to retaining one's membership or retaining one's incumbency in office once elected, correct?
The General Assembly has said you have to
That's not
affiliate.
that was a simple question.
Then the answer would be no. Yeah, I'm sorry.
Okay, the General Assembly has within its power the ability to prescribe when an incumbent might resign based on circumstances.
That is 100% accurate, yes.
Okay. The General Assembly has in some cases prescribed, for instance, that a resignation is necessary under certain circumstances from public office.
That's true.
They have never prescribed that an incumbent must resign upon disaffiliating himself with the party.
That is not in the statute. That language, you're correct. It's in the statute.
They have never done that.
That's-
So what you have is that it is one factor among many factors that the board may consider.
I said.
Very good. We agree for once. We agree on something. You in the brief and in your testimony have made repeated reference to Mr. Bernabei serving as the Democratic County Commissioner. Where in the revised code will I find the phrase Democratic County Commissioner?
You will not.
Why wouldn't I find that phrase?
Because the fact that he's a Democratic public office holder is based upon the nominating petitions that he circulated, which form the basis of his election, and the fact that the Democratic Central Committee will appoint his successor.
In order for Mr. Bernabei to disaffiliate himself with the party, are you of the mind that he must have a complete ideological break with all its tenets?
I don't understand the question. What do you mean by that?
Can Mr. Bernabei quit the Democratic Party and still hold some fidelity to some of the principles of the Democratic Party?
Yes. Yes, I think that's fair.
And that wouldn't make his disaffiliation any less genuine.
I think that's right, but that's not what we have here.
That wasn't my question. The answer ended at right. Let me ask you another question. In the brief, it says that not one night did Tom Bernabei sleep in University Avenue.
No,
The brief says that as of the 3rd, he had never slept in University Avenue?
that's what the brief says.
Why is that relevant?
Because when he signed his nominating petition that day, he's making a representation under penalty of perjury. That was his voting address, and another secondary reason as to why it's relevant. We've learned since reading your brief that he actually signed his change of voting address on April 30th. and the document was forward dated. So the fact that he is not sleeping at that university address of May 3rd, I think it's very relevant.
Do you know when he formed the intention to begin staying at University Avenue?
I am not Mr. Burney, you would have to ask him.
We will ask him. Is it safe to infer that someone doesn't typically spend $1,000 to enter a month-to-month lease to rent a residence in which they don't intend to stay?
I mean, people rent hotel rooms all the time, and I'm sure that was about the same cost. Who knows? What is in his mind, Plakas?
You rent any $1,000 hotel rooms? You must be doing pretty well. Is there a formal mechanism for assigning of membership to the Democrat Party?
There is not.
Are you aware of who is funding this litigation on behalf of the Democrat Party?
I am.
Who is?
Judge, when we talked about internal law firm finances, et cetera, this court has already indicated that we should stay with the specific issues already raised. I put that note, there was one fishing expedition, we're going to just go through a number of fishing expeditions. Judgment sustained.
Were you aware when you read the protest that to the extent Mr. Bernabei did not intend to remain in University Avenue, it was always his intention to create another address for home vacation?
That's what he said.
Were you aware when you wrote the protest that that was the case?
Clearly, because he's saying his address at university is temporary. If he's intending to move somewhere else, that's what makes the address at university temporary.
And the last part of that question was, were you aware that someplace else was another residence within the same jurisdiction that would equally qualify for realty?
He shouldn't have been there.
I didn't ask that. I asked, were you aware?
I am aware.
What is the answer, yes or no?
The answer is he intended to make his permanent address a Lake Crest property.
You will agree with me that there are colloquial uses of the word permanent and that there are legal uses of the word permanent and that they sometimes diverge.
I don't agree with that.
You don't agree?
No.
So one can talk about a permanent address and one has only one definition of a permanent address. Is Mr. Bernabei now permanently residing in Lake Crest to your knowledge?
To my knowledge.
Yeah. So what if 2 years from now he decides to move? That retroactively have invalidated the permanency of his present residence?
No, I don't think that. I think that the issue in the case is whether living in a house for 3 days is permanent. If that's the case, then the word permanent has no meaning. Staying in a hotel for a night is permanent under that theory of what you've articulated. So to answer your question directly, I don't agree that there are two definitions of the word permanent, a colloquial definition and a legal definition. Permanent is permanent, and the residence of the university was not.
But you will agree that the word permanent is defined specifically in the statute as the place to which one intends to return when absent therefrom, and that the statutory definition, not your characterization of permanence, is governing.
No, I don't agree with that. The statute says the place of fixed habitation is what determines where you live. The Secretary of State, who we have to rely on, says that means cannot be a temporary resident, it has to be a permanent resident.
The statute does not define the fixed abode as the place to which one intends to return when absent. Which is,
In some respects, I think that's about, yes, that wasn't your original question, but I think that's what the statute says in some respects.
and the statute governs what constitutes one's residence for purposes of voting and elector status.
No,
The statute doesn't govern what
No,
governs.
no. The General Assembly has said the Secretary of State's opinions have to guide the court's determination. The Secretary of State's interpretation is what the board should be looking. I believe the statute, the General Assembly has said the Secretary of State is what should be guiding the court's determination.
So you're saying that the General Assembly has delegated its authority in regulatory capacity to the Secretary of State to make regulations that supersede or interpret its own statutes? Is that your
I'm
claim?
saying the Secretary of State's charge statutorily with interpreting the election laws. This board relies on, the board relies on the Secretary of State opinions every day. This is not a foreign constitutional board.
So the board should probably rely on Secretary of State Gruber's decision in opinion number 2007-5, where she says that Ohioans retain the right to disaffiliate themselves and alter their political affiliations at any time. They should rely on that too, shouldn't
They
they?
should rely on the entirety of the
Okay. All right, we're done, thank you. Oh, you're so right. So, yes, that's true. I have it all my side. I forgot to ask you something. Seems to be a very large portion of your brief given over to the theory that Mr. Bernabei is motivated to run for mayor of Camden because he harbors some need, some deep-seated need for revenge against Mr. Healy. You remember that, don't you?
I do.
You wrote that, didn't you?
I did.
Is that your theory?
I believe it's supported. I believe it's beyond a theory.
It's
I believe
beyond
I believe
theory.
it's factual.
Oh, it's a fact.
At least a portion of his motivation, I think, is undeniably attributed to his ill will towards the mayor.
I see. And how do you know of this law?
He's told me personally at lunch while sitting with vendors probably about a year ago.
Tom Bernabei told you that he's ready to run for mayor because...
No.
What has he told you?
He told me how much he he's told me that he very much dislikes the mayor of our city, and that choice words, but I'm going to go into detail. And I think the fact that we heard today in Mr. Bernabei's testimony that the termination is being called out by the cops while he was laughing. I mean, the human condition is there's going to be some elbow there. There's only certain things that can explain this bizarre course of conduct leading up to the final deadline. Whether it's ultimately hatred for the mayor, feeling that only he can save the city of Camden, I can't get in his head. But when you apply the advisory opinion to the facts of this case, the conclusion speaks for itself.
Can't get into his head. But you didn't hesitate for page after page after page in the brief trying to get into his head and speculating about vengeance as the motive. You did speculate about vengeance as the motive.
Right, I don't know that.
Right. You're not a psychologist,
I'm
are
not a
you?
psychologist.
You're not a psychiatrist, are you?
I'm not a psychologist.
You're not a mental health professional.
I'm not.
You've now had the opportunity to discuss with Mr. Bernabei his motivations for the present run, have you?
I've not.
Okay. In fact, how long have you been in politics?
4 years.
How old are you?
33.
All right. So you've been in politics for 4 years after Mr. Bernabei's 40. How much history do you have with Mr. Healy?
4 years, right?
Okay. How much history does Mr. Bernabei have with Mr. Healy?
I know of at least one where they worked together.
Right. What do you know about that?
I know that Mr. Bernabei said that it was a marriage that wasn't going to last.
You see. When was Mr. Bernabei terminated by Mr. Healy?
January 2009.
Okay. And are you aware that your own brief, the one you drafted and for which you assembled the tables, demonstrate that he's given $26,000 to the Stark County Democrat Party since that termination?
Okay.
Does that seem to you to be a man who's harboring bitter revenge toward his party?
No, I think you're conflating the two concepts. It's not, Mayor Healy is not the Democratic Party.
Forgive me.
The ill will towards Mayor Healy and his donations to the Democratic Party as recently as April 26th, I think, it doesn't make sense, to say the least.
I'm not sure I understood your answer, but I'm not sure that I need to. Have you ever had the opportunity to be present during the 6 years as commissioner when Mr. Healy and when Mr. Bernabei and Mayor Healy worked together on the sorts of issues that urban mayors and county commissioners work on?
I think those issues are few.
You think those issues are few?
I know those issues.
How many meetings have you attended?
Commissioner meetings?
Now, how many meetings have you attended wherein Mayor Bernabei or Commissioner Bernabei and Mayor Healy met on city-county business?
I have not attended any of those meetings.
Okay.
If
How many interactions between Mr. Bernabei and Mayor Healy have you had the opportunity to witness since 2009?
I've never seen her. I've never seen Mr. Bernabei come to our council. I've never seen Mr. Bernabei at Kansas City Hall.
Has Mayor Healy ever expressed to you the feeling that Mr. Bernabei was gunning for him politically?
Like with this candidacy?
In any way?
No, I don't think. I think certainly he's filed a petition running against the mayor. I think he's gunning politically, but prior to that, no. I don't think so.
You opine in the brief that Mr. Bernabei has some sort of messianic complex that he alone can solve the problems of Canton. And it seems to be suggesting that there's a certain degree of arrogance. Is that a fair characterization?
I'm not characterizing anything that Mr. Bernabei has said.
Except in the brief that runs on for about 12,000 words.
I'm sorry you didn't appreciate that.
I didn't appreciate it, but I made it through. Now, in that brief, you speculate as to his motivations. In that brief, you speculate as to his lack of political candor. Do you have any personal knowledge to demonstrate that Mr. Bernabei is a man who undertakes political decisions lightly?
I don't have any knowledge more than that.
Do you have any knowledge to indicate that Mr. Bernabei is a man who doesn't take seriously the ramifications of his actions?
I have no knowledge more than that.
Do you have any knowledge to indicate that Mr. Bernabei uses petty grievances as the basis or the motivation for his public actions? Do you or don't you?
I have a lot of respect for Mr. Bernabei.
Good.
I think this whole, I think this is out of character.
I see. So you formed an opinion as to his character.
Yes.
And what is that opinion?
I think he has a good character, and I think he has a general reputation in the community for good character. And I think that this issue doesn't match up.
I have no more questions.
Mack, I'd like to follow up on some of the questions that you were asked on the subject matter that were gone into the, weren't permitted to fully answer. The last question, you were asked to talk about Mr. Bernabei's character, and you stated that his conduct in this situation doesn't match up. Tell us why.
The reputation that I know of Mr. Bernabei is detail-oriented and studies the law, and thus things the correct way. This was clearly not. Whether failing to send, for instance, the letters to the different Democratic clubs, whether by design or by mistake, that's not a type of mistake that if someone's going to do this, it's such a serious decision. When there's the issue of failing to resign from his county commissioner's seat, that is something that's fairly obvious to do in order to satisfy the independent candidate. I'm surprised that Mr. Bernabei would be acting consistent with his character, as I understand it. He would have done that.
You just mentioned that it would be appropriate and surprising if he hasn't resigned in terms of meeting the qualifications. And you've already been questioned, is there any statute that says thou shalt resign?
No.
How do you respond then? Why is it so important in your analysis, as you were questioned by Mr. Bernabei's counsel, that a Democratic office holder must resign to clearly disassociate himself from the Democratic Party?
Well, like I said earlier in my remarks, the advisory committee clearly will guide this court's decision. And that situation is discussed specifically within the advisory opinion itself. And if you have Democratic office holders, or Republican office holders, I'm not limiting it to one party or another, allow them to hold elected office, be affiliated with a political party, or that political party executive committee is going to make the appointment, and then permit them to run to an independent, and the affiliation requirement has to be. It would make no sense. There current sitting office or the fact timing of the resignation to the petition of the files. This has never happened on our court.
You were asked about or referred to a 2007 opinion from Jennifer Bruner, and you weren't permitted to explain the entirety of the opinion. With regard to that series of questions that was asked of you, would you please explain the relevancy of the entirety of not only that opinion, but any other guidelines that have been issued that you think are relevant by both the Secretary of State's office and the court system?
Objection. Question.
He asked. This is inspection. If you could proceed. Thank you.
The analysis starts with the Morrison decision, and that's from the Sixth Circuit. And that's when the Sixth Circuit first applied the independent requirement, the disability requirement in Ohio law. It was enacted in the 80s. Jennifer Bruner then issued an advisory opinion to determine how you apply Ohio's disaffiliation requirement. And Ohio is not unique to have a requirement that independents have to be disaffiliated. Colorado, Oklahoma, California, a lot of states do that because the policy is not under the policy, but the board knows the policy is to protect the rest of the value. The advisory opinion then analyzed its application of the Morrison decision. The Morrison decision said, in order to fulfill the statute, two things have to happen. Have to be disaffiliated, actually disaffiliated. And then number two, disaffiliation has to be done in good faith. So the advisory opinion establishes different factors that this board may weigh to assist it in that evaluation. There's two automatic disqualifiers. This board is well aware and has disqualified candidates based on these automatic disqualifiers. Voting in partisan primary and five-year positions or serving on an executive committee after positions. If the automatic disqualifiers aren't present, then there are numerous factors that this board will examine in a way to determine affiliation. Voting history, but voting history alone has to be more if the board is disqualified. Sorry about that. It has to be more than just voting history by itself. Office as a current elected official, political donations, membership in organizations, anything that would demonstrate a continuing affiliation with the political party is something that this board would look at. Since the advisory opinion, it's been applied by the Ohio Supreme Court, by the courts of appeals, by a lot of courts of elections throughout the state. The case that is closest to this, well, let me take a step back. In Supreme Court cases,
I sort of lost track of the question. And so,
sorry.
Advisory.
Sorry.
Understand that. But maybe we go back to a particular.
Sure. You're going back to the suggestion made. Okay, you don't really answer. The suggestion was made that there's nothing that prohibits in the advisory opinions or the statutes or the case law, there's nothing that prohibits what Mr. Bernabei is attempting to do. And you were permitted to give a full answer to that. What is your answer to that?
No, the advisory opinion itself absolutely prohibits what is wrong.
There was also a line of questioning that you were asked regarding the address and the timing and the date upon which he signed certain declarations or applications. And you made a point with regard to discovering some statement made in the brief that was made in Mr. Brewley's brief that was contrary to the documents or so facts that appeared before that. What did you mean by that? Please explain.
Mr. Bernabei caused to be filed at the Board of Elections on May 3rd, a change of voting address form to change his address to the university property. We did not know that document was actually signed by Mr. Bernabei and provided to the deputy director on April 3rd. So when that document was signed, under penalty of election falsification, his lease wasn't even effective for the property.
And that reference to that April 30th, that is contained as a matter of the law in this case in Mr. Bernabei's brief that was filed late Thursday or Friday.
That's right.
You were also asked about the nuances between a temporary resident and permanent resident. The suggestion was made that there's really no difference clearly in terms of those terms. And you responded, and we're not going to fully respond, but for example, in the case law or in the advisory opinions, do they consider the difference between temporary and permanent meaningless? Is there a colloquial acceptance that, oh yeah, this is permanent or temporary and it means the same thing?
No.
And in the following up on that question, with regard to temporary residences, et cetera, does the case law, for example, allow, or the advisory opinions allow, potential prospective voters or candidates to move into an area and take a hotel room for a period of 3 days or a week or a month, and then be qualified or eligible to be voters or candidates?
No. In the Brooks case that we cited in our actual brief, the third district was very clear. Hotel room cannot be a valid voting residence. It will go to in that case. And in our supplemental bench brief that we filed today, there's a Supreme Court citation where they looked at the situation not as dramatic as this one, but where a candidate moved into a residence with the sole purpose of running for office with the wife and dog staying in the other house. That's what it said. It's not a permanent voting residence.
You were further questioned, and there's a line of questioning, made reference to certain dates and even Mr. Bernabei's wife, and you were permitted to fully respond to that question, and the issue in that question was, is there any relevance, and what's the big deal if in fact your wife doesn't move when you move, and what was your response if you weren't permitted to give it in that question?
That's highly relevant. If, for instance, if you look at Exhibit 127, our supplemental appendix, Mr. Bernabei's wife actually on May 5th voted in person at the Hills and Dales address. In the statute, when you determine someone's residence, it says the residence of the spouse shall be the place of residence. Now, we have, when you take into consideration permanency and temporary components of this case and combine those with the statutory requirement, the location of the person's spouse shall be determined as a residence, that's very relevant.
And then based at least upon the documentation, there was a line of questioning with regard to whether or not Mr. had actually been sleeping at the premises at the time that he actually filed some of the or the petition and the declaration, and you weren't permitted to answer that. Have you done an analysis, and have you created, just to speak this up, any sort of timeline that the board should review to confirm whether or not Mr. Bernabei had actually slept there before he submitted his petitions on May 3rd?
Yes, at Exhibit 122 in the supplemental appendix, we created a timeline that details when the forms were signed, when the Democratic contributions were made in relation to the relevant trigger dates. And the second page of that is the citation in the record to every document that supports every entry.
And with regard to the question and the subject matter that was asked by Mr. Bernabei's attorney, what is the relevancy then of the timeline? What does the timeline show on page 122?
It documents everything that would demonstrate continued affiliation both after the petitions were signed, after the petitions were filed, and
regard to the timeline, the question being asked about Mr. B sleeping, what is the relevancy that you were permitted to respond to in regard to, in someone claims that they've established a residence, what is the relevancy of whether they have slept there at the time they're claiming residency and or whether the wife is there?
That's right, it goes to both issues of the permanency of the residence and the statutory language indicating the work person's spouse. When both certainly the change of voter registration form was signed on April 30th, he didn't have a validation of residence, and when his petitions were signed on May 3rd, he had never slept there today.
And why do you say, why does the timeline confirm that when the petitions were signed on May 3rd, he had not yet slept there? What is the basis and the evidence for that?
The statements that Mr. Bernabei made in the Mark Wilson interview provide the foundation of that.
And what specific statements are you referring to?
When he came back to Florida and contrasted with the dates of the different documents being signed.
Well, specifically, the last question, how do you mean that? So what date did he come back from Florida? How does that compare to the filing of his petition? And how does that compare to again for the first time sleeping there May 3rd when he came back from Florida on the afternoon of May 3rd?
That's it. He came back from Florida on the afternoon